Thank you. Okay, I think we have a few people now joining us. So good afternoon and welcome everyone for another ANZCCJ webinar. My name is Emily Hallams and I am the Executive Director here at ANZCCJ. And today I'm delighted to welcome you for this session covering Japan's work style reform laws and how these reforms have been impacted by COVID-19. Today's webinar will be moderated by our very own Catherine O'Connell, who in addition to serving as the ANZCCJ Co-Vice Chair is CEO of Catherine O'Connell Law, her own law firm established here in Tokyo in 2018. I have no doubt that her wealth of experience in both in-house legal counsel and corporate law will be a strong asset to guide us through today's webinar. And we'd like to thank Catherine for making the time in her very busy schedule to be with us today. Our guest speaker is Mr. Hiroshi Chiba of Chiba Law Office, who is an expert in commercial and labour law with extensive experience hosting legal and business seminars in both Japanese and English. I will hand over to Catherine shortly to formally introduce Mr. Chiba and today's topic. Before we begin, I will remind you all that we will have time for questions at the end of today's session, and these can be sent through at any time through the Zoom Q&A function, which you should find a button on the bottom of your screen there. Alternatively, you can also email your questions to us at ANZCCJ through info@anzccj.jp. So without further ado, I'd like to pass over to Catherine to get us started for today's session. Thank you, Catherine.
Thank you, Emily, and hello to everyone. Of course, thank you again for joining us today for the Australian New Zealand Chamber of Commerce and Japan's webinar on Japanese work style law reforms and the impact of COVID-19. As Emily mentioned, I'm one of the co-vice chairs. There are three of us. I'm just one of three. And I'm a registered foreign attorney in Japan running my own practice here. Before I introduce Chiba-san, I would like to just cover a couple of additional housekeeping topics. And one of those, as lawyers, we always have to say this, that today's webinar is informational and educational, and it's not meant to apply to each and every scenario. So the views expressed today by Chiba-san and occasionally by myself are really not legal advice, right? So you should really seek legal advice on your specific labour law questions. And the second housekeeping item is, as Emily has mentioned, please do participate. We do want you to participate and invite you to do that through the Q&A and also via email, as Emily suggested, for those of you specifically who are on the phone. So I would like to now get ahead and introduce Chiba-san. Mr. Hiroshi Chiba is a Japanese bengoshi lawyer. He specializes in civil affairs, labour law, insurance, and corporate law. Chiba-san set up his own practice in Chiyoda-ku in Tokyo in 2008, and he's a member of the Dai-ni Tokyo Bar Association. We both became lawyers around the same time, actually, in 1994, and both of us have been therefore practicing, if you can do the math, 26 years or so. Mr. Chiba is active in Tokyo. He is active in the business community. He provides lots of really easy to understand breakdowns of legal topics. And so I'm sure you'll really find today's content easy to understand, informational, and, well, easy to digest and take away with you afterwards. So at this time, I'd like to hand the floor over to our speaker. Chiba-san, over to you.
Thank you very much, Catherine. Hello, everyone. My name is Hiroshi Chiba, a Japanese lawyer. Labor law is one of my expertise, and I'm so much honored to have such a precious opportunity to give a seminar, webinar to the members of ANZCCJ. I have conducted so many seminars on Japanese legal matters with the help of the subsidiaries of banks like SMBC or Mizuho, or newspaper company Nikkei, and so on. So that's why I'm here. And today I'm going to speak about the amendments, recent amendments in the field of Japanese labor law, and something about COVID-19. I have prepared some slides beforehand, so let me share it with you. Just a minute, please. Can you see them? Is it okay? Okay. So today, I'm going to talk mainly about the recent amendments in the field of Japanese labor law. As you know, in these last few years, Japan has experienced a few important amendments in this field as a part of so-called work style reform legislation. Today's webinar has 3 parts. Here it is. The first one is amendment in 2018, the next one 2019, and some points regarding COVID-19. These 3 topics are mainly main topics I'm going to talk about today. Let's begin with the first one. Amendments in 2018. For the first time in Japan, they set some limits in the amount of overtime and work on days off. And it entails punitive provisions. That's why it's very important. In detail, there are 3 regulations. First, I'll introduce them to you. Here they are, these 3 regulations. The first one is, as you see, overtime per year must be within 700 hours, which means roughly 59 hours a month. It is about the amount of overtime. And the second one is total of overtime and work on days off in a month must be less than 100 hours. There are 2 points we should pay attention to about it. It says less than, not within. It's different from the first one. So just 100 hours is not good, but 99 hours or 95 hours are good. We must pay attention to it. And the second regulation includes overtime and work on days off. So the total amount of them should be less than 100 hours. The first one is referring to only to overtime hours. Here's another difference. And the last one is the average of the amount of overtime and work on days off in a month must be within 80 hours. It's average of the total amount of overtime and work on days off. So that's a point we are going to talk about. What is your impression about it? Is 100 hours a month loose or lax? But even if we say 100 hours overtime or so are permitted, once we spend all of them in a certain month, we must lessen the overtime hours to the level of less than 60 hours next month to meet the limit of monthly average amount. It may be severe in some cases. And this amendment in 2018 was put in effect with large companies last year, and since April 1st this year, it was applied to small and medium-sized companies. Regarding this amendment, what you must pay attention to is whether you know what working hours actually means. That's the point, whether you know what working hours actually means. It's very important. Without proper knowledge of this point, such cases will happen as you don't think there are overtime hours, but actually there are so many objectively. Working hours are defined as hours under the direction and supervision of the employer. That's the point, hours under the direction and supervision of the employer. Here are some examples to consider. Here there are. There are 3. Standby time, workers who come to the office earlier than the official starting time, mandatorily carrying a mobile phone. Let's begin with the first one, standby time. What about standby time? Is it working hours? Here's a more detailed situation. Again, a truck carrying materials which was supposed to arrive hasn't arrived yet. It seems that there's been an accident and there's a heavy traffic jam. The workers who are to unload the truck have nothing to do. So the company told them to wait for a while, standby time. Is this standby time considered to be working hours? They are not working. They are only chatting, perhaps. But of course, most of you know the answer. Is this standby time working hours? Yes, it is, of course. Such an idle time is usually regarded as working hours. What I'd like to say is, the most important is whether you are aware of the reason for that. Why does it become working hours? As I have said, working hours are defined as hours under the direction and supervision of the employer. Even if they are allowed to do anything they like, such as chatting, once the truck comes, they must return to the workplace readily. There is such an implicit premise. That means they are under the direction and supervision of the employer. What about the next one? Workers are coming to the office earlier than the official starting time. A worker comes to the office earlier than the official starting time. For example, 7:45 a.m. instead of 9 a.m. He comes early because he wants to avoid congestion. At first, he reads the newspapers, but he gets bored gradually and starts up his PC at his desk. In the end, he begins to work. Is all of this time since 7:40 a.m., 45 a.m. considered to be working hours? Perhaps some of you know what I want to say next. Is the worker under the direction and supervision of the employer? What matters is that usually such things happen every day. When officers of labor standards inspection office come, there is a high possibility that they regard the morning hours as working time, because the company allows the workers to come in and to begin working earlier. In the end, the company puts the workers under the direction and supervision of the company. Strict companies won't let workers come into the office, or at least ban using PCs before the opening time. Another example, mandatory carrying a mobile phone. This example is the case that recently I am asked about so often. A company has workers carry a mobile phone and orders them to answer phones from customers, in some cases 24 hours a day. Are the workers under the direction and supervision of the employer? That's a point I'll repeat again and again. But in this case, it may be a little difficult. Are the workers in this case under the direction and supervision of the employer? You may think so. They have to answer the phone calls anytime. But isn't it strange to see this situation as putting employees under the direction and supervision of the employer 24 hours a day? So a more understandable way to decide, which many judicial precedents have used in judging, is whether the workers are assured of release from working, whether they are assured of release from working. There was an example like this. It was a real case. A company allows its workers to take a nap for a period of time, but these workers had to stay in a certain location, which was a room, and had to continue to answer any calls that came in from customers. That was the situation. In this case, the workers were not assured of release from working. They had to be there and they had to answer the phone calls. So in the end, the judges decided that the time for nap should be counted in as working hours. Specifically, how strongly the worker's activity is restricted is a point. Imposing first place restrictions and second time restrictions is not good. If there's no place restrictions, the possibility to be decided as working hours is not so high. Regarding the case of workers carrying mobile phones, if there is no place restriction, the possibility that it is regarded as working hours is not so high. Another example that we can say the same thing is time to wear uniforms. If a company orders the workers to wear the uniform in a particular place and at a particular time, it should be regarded as working hours. Let me repeat it. Please be conscious of the definition of working hours. To be able to decide objectively is very important. And at the end of this topic, I'd like to comment on the way we calculate working hours. How to calculate working hours. Employers are obliged to grasp working hours, of course. How do you calculate working hours? Here are some examples as you see them. Time cards, computer logs, and so on. We can use any of these methods to calculate working hours. With the spread of the virus COVID-19, cases of teleworking increased. In such cases, how should we calculate working hours? Sometimes companies may use a third one, deemed working hours system for work outside the workplace. This system allows the companies to deem that the number of hours worked is prescribed working hours. But this system is used only when workers perform their work outside of the workplace and when it is difficult to calculate working hours. That's the point, when it is difficult to calculate working hours. Teleworking does not necessarily mean that to calculate working hours is difficult. For example, there are some software which monitors the way PCs are used. With that, it is easy to calculate working hours. Labor Standards Inspection Office may not admit to apply the system of deemed working hours when the workers work at home. We have to be careful about it. In such cases, companies may introduce the last one, self-reporting system. But it is said that there's a strong possibility of underreporting. So there are some points to be noted, shown in some guidelines. Generally, Japanese people are so modest that they are said to have a tendency of short reporting. So there are some rules for that. But you may think, what if there is an over-reporting? But there is no guideline for that. Such things are beyond expectations in our country, in Japan. Though I can't mention in more detail today, but please remember how to deal with the working hours is an important matter, very important matter. Let's move on to the second one, amendments in 2019, which is effective from April 1st in 2020, this year. Some of you who may think it as a matter of course, equal pay for equal work. It's natural, it's as a matter of course, but in Japan, it wasn't. Years ago, some judicial presidents said that there was no such concept in Japanese law. For the first time, new laws brought it into our society. What I want to say is that it's important to know at what point you have to treat employees equally. You don't need to take measures to realize equality in everything. Specifically, what matters is the balance between full-time and part-time, and between temporary and permanent workers. In other words, regarding the balance among permanent workers, there is no regulation by laws. Then we go to the details. There are two requirements. The first one is, as you see, equal treatment. It means if their tasks are the same, they should be treated equally. And the second one is balanced treatment. If their tasks are different on some points, they should be treated differently accordingly. In reality, in Japan, the examples of the first one is not so large in number. So usually we have to pay attention to the second one. How should we deal with it? Please give it some thought. If some of the part-time workers come and ask the reason why there is a big difference in working conditions compared to those of full-time workers, can you give a satisfactory explanation for that? There are 2 points you can use mainly. The points are like this. The first one is whether there's a difference in their duties. If full-time and part-time workers are in charge of different tasks, it can be used as a factor to explain the reason with. For example, there is a supermarket, and usually both people do the same task, such as arranging merchandise on the shelves. But when a customer comes to make a complaint, it is on full-time workers to cope with it. They should shoulder the complaint. Part-time workers won't do that. In this case, there is a difference, so it's okay. It can be used. Their main task is the same, but their subtask is different. If you have both people do just the same thing, to explain the reason of difference would be harder. Besides the kinds of or range of tasks, how heavy their responsibilities are can be taken into consideration. An urgent incident happens and they have a lot of tasks to do within a day. But basically, the full-time and permanent workers work overtime, and all part-time workers can go home as usual. It's okay again. It's another factor we can use in explaining the difference. These are the points which are included in the first point, whether there's a difference in their duties. The second point to explain the difference is whether the system of using human resources is different depending on the position of the workers. It may be a little difficult to understand, but mainly the range of transferring a person from one location to another is a matter. If a part-timer is not transferred, which is different from permanent workers, then the different working conditions can be justified. Any other differences can be used accordingly. These may be a little difficult to apply, so let's think about it using an example of allowances. About 2 years ago, 2 famous decisions were made in the cases named like this: the case of Nagasawa Unyu and the case of Hamakyo Rex, and how we should consider each allowance was revealed. First, there are some steps, as you see. First, we should start with the meaning of the allowance. What kind of meaning does it have? Then we should consider how it is connected with the working duties. And lastly, how it is connected with their range of transfer. For example, let's think about commuting allowance. What is the purpose of this allowance? The purpose of this allowance is to, of course, to lessen the burden of commuting cost. It is not different depending on their position. We can't say the need to be covered by the company is lighter if the worker is a part-timer. The range of transfer has nothing to do with the need to cover the commuting cost. In the end, the companies should pay this allowance equally. We should take such steps every time with every allowance. In more detail, you can examine the contents indicated by the Japanese Supreme Court 2 years ago, as I have mentioned. In general, many companies in Japan are trying to decrease the kinds of allowances, thinking that to have various allowances is just a cause of troubles. Lastly, let me allow to give some comments on the issues that arise through the spread of the virus from the viewpoint of Japanese labor law. Unfortunately, there may be a time when we decide to terminate the contracts with some workers because of the economic situation caused by the virus. In such cases, is dismissing someone easy? Of course not. As you know, Japan is famous for its traditional lifetime employment system. The workers are strongly protected accordingly. Do you know this concept? There are two requirements to satisfy to dismiss a labor contract, which we call the employment dismissal regulations. The two bills to fill are like this, as you see. The first one is the dismissal should have objectively reasonable grounds. And second, the dismissal should be considered to be appropriate in general social terms. And what is more important, the burden of proof lies with the employers. It is very harsh for the employers. Additionally, in such a case that the dismissal is decided on account of a deteriorating business environment caused by the virus, it is not the worker's fault. So the situation may become much harsher. In Japan, such a kind of dismissal is called dismissal for the purposes of reorganization, and there are 4 strict prerequisites to fill. It is as a matter of course that the regulations is very strict because the workers are not wrong. They are so severe, these 4 conditions are so severe that the success rate of employers is roughly 20% when the case is brought to the court. It's very severe. The requirements are like this. The first one is business necessity. And there must be a strong necessity of the personnel reduction. It's of course. And the second one is efforts taken to avoid dismissal. It means that dismissal is admitted as a last resort. And the third one is rationality in selection of personnel to be dismissed. The selection should be done fairly. And the last one is agreement between management and the affected workers. It does not necessarily mean that kind of agreement is necessary, but the employer should take his best effort to gain consent of workers after adequate discussion. To fill these prerequisites is very hard. Even if some companies do that, sometimes we see such things on media. But even if there are some companies which do things like this, it may be dangerous to copy them. This year, similar cases are reported regarding employment offer. Can it be possible to withdraw it on account of the deteriorating business environment? Judicial precedents regard employment offer as a kind of working contract. So to withdraw employment offer is basically the same as a case of dismissal. It is severely restricted like dismissal for the purpose of reorganization. It's the same. You must carefully consider whether the 4 prerequisites are satisfied. It is not so easy. And that is what I want to say. I want to talk today. And thank you for your kind attention.
Great, thank you, Chiba-san, for your really informative presentation. I think as I was listening to you there, I have perhaps 3 takeaways that you talked about. And first would be that employers really need to be very, very careful about that understanding of what working hours means, considering the facts in their workplace. You know, the examples that you provided were very helpful, such as being on standby for customer calls, which is still a, you know, even though we're working at home now, that's still a requirement. So they were really easy to understand. So thank you for those. Secondly, I think it's really clear to me that these laws have come into place, and especially the second one that you mentioned, equal pay for equal work, that really started in April this year for all companies, right? And so, you know, it was perhaps an excuse at the beginning during COVID-19 or the state of emergency to be slow to, you know, complete those rules. But now I would say that implementing is important, that everybody really needs to do that. And COVID-19 is probably not an excuse anymore.
That's right.
And then third, dismissals. It's so true in Japan. To tread carefully around dismissals is always so important. But I think in this era of COVID-19, with that operating system in our society, we really have to be very careful, even more so, especially that statistic you said, you know, 80% failure rate at court to justify the dismissal. It really does mean employers who are considering dismissals, especially in this time, should be very careful and seek legal advice. So really appreciated those. And so from now, since we have another 25 minutes or so, we're going to move to Q&A. And there is one question that has come through, Chiba-san, on the live chat. And we do have some other questions that have come in before the webinar, so I'll also address those. And thank you very much for the question. The question is, Chiba-san, do you see that there's been an increase in the number of cases at domestic Japanese firms in which more employers than in the past issued performance improvement plans in a way to justify the dismissal of the employees? So more cases than in the past using PIP, the performance improvement plan, to justify dismissals. So you didn't speak about this, but it is a question that's come up from the attendees today.
Yes, I have heard that some companies are trying to do such a kind of things. Of course, most companies are in a severe situation because of the virus, so they have to take some methods for that. But the methods which is mentioned in this question, I think it's a little dangerous because the terrible situation is the same on the side of the workers. Once the case is brought to the court, the judges must make much of the benefits of workers during the hard situation. So we have to be careful in using such a kind of things. Usually, we have to think of the benefits of the workers, and first we should, it's a company. The company should take some measures to lessen the damage on the workers' side. And in the end, there may be a time they have to dismiss the workers, but it must be a last resort, as I mentioned in the webinar. So to take it for granted that we can use such a kind of methods under this situation is not good, I think.
Right, and as you mentioned, it's only one component, right? A performance improvement plan is just one component of the many things, or especially the 4 key topics you mentioned that are required to justify the dismissal. But that's a great question. Thank you for handling that one nicely. So another question that came in before the webinar, and I thank people for submitting those, is can you actually enforce employees to go back to the office if they're reluctant to do so? And they may be reluctant because of the fear of catching the virus during their commute, for example. Can you force employees to go back to work?
Of course, it is understandable that employees have such a kind of feeling to go out, especially to take a crowded train, makes us feel the possibility to be infected. But seeing the current number of the newly infected patients, though we know there's a spike in Tokyo now, but we can't say that there's a strong possibility of infection if we go out. The fear of employees is understandable, but it is only abstract, vague uneasiness in the end. This cannot justify their refusal to work. In conclusion, even if employees hesitate to come, the company can order to come to work. But however, there's one thing that employers must be careful. They are required to take adequate and proper measures to prevent infection, of course. If such measures are not taken and the situation is so, as you know, employees can refuse to work. So in that sense, it depends.
Okay, so you said at the end there, if such measures are not taken, and the situation is the so-called 3 C's.
Yes.
You just cut out a bit there, so employees can refuse to work if there's not those three C's in place.
That's right.
Understood. Tim, I've seen your chat there. Could you just clarify what you mean there by, does this also cover the commute? Could you, I think you probably mean, can they be forced to come back to the office? They're reluctant to do so. During the commute, we just answered, but could you just clarify that question a little bit further, and then I'll come back to you on that. In the meantime, I'll just go to the second question that we received from before the webinar, and that was, if you ask an employee to work in the office in this pandemic situation, Chiba-san, can that employee claim anything against the company in the case that he or she contracts the virus?
Basically, it is the same as I said on the previous question, the first question. Workers have right to demand their employer takes adequate and appropriate measures. If an employer neglects its duty and the employees are infected, the employer might have to take responsibility for breach of its security obligation. regarding this security obligation, it is an abstract concept, and we must pay attention to the fact that its detailed meanings are variable from hour to hour. For example, the concept of social distancing was not so familiar to many people, but now it has become common knowledge. We should always keep an eye on media and what kind of measures are taken in the society. On the other hand, even if a certain measure is not taken in general, it does not necessarily mean that we don't have to take responsibility for neglecting or taking the measure. If we feel risky under specific circumstances, we should take every possible measures for that.
Okay, and so thanks, Tim, for clarifying your question. So that responsibility of employers to provide a safe working space, Chiba-san, does that also extend to ensuring that employees are safe on the commute to and from work? So is the workspace only the workspace at the office, or does the employer have that responsibility to also protect the employee during the period they come to work, say if they're on the train?
Generally, companies or the employers don't have to take responsibility the situation during the commuting. Of course, it is related to working, but during the commuting process, the employees are not under the control of the employers. So the company doesn't have to take responsibility for that. Of course, in a particular case like in this line, there occurred so much cases of infection at a time, and so on. And if the company forces the workers to commute using the line, the company may be responsible for that. But usually or generally, I can't imagine that the company should take some responsibility for that. So it's okay for the company to make the worker commute. But of course, taking some measures like making the workers in a different timing of the day is beneficial to avoid taking responsibility to some extent.
Okay, as an extension of that, what if the employee is required to do a business trip within Tokyo, go to visit some area that's part of their work during working hours, and they have to take the train for that? Is that considered workspace, or is that considered just a commute that is not part of work? So during that business trip, are they the employer required to keep the safe workplace while that person's on the train?
I think it's the same as I have said in that case. Okay. So even if the workers are infected during the train, during riding on the trains, usually the companies won't take responsibility for that. Of course, they should take proper measures to avoid infection as much as they can. For example, giving enough education on how to avoid being infected to the workers. And of course, they should try to keep hotels outside of the infected area, which is commented recently so on.
Sure.
But taking such measures, the responsibility of the company would be so so little in the end. There is little possibility for that.
Okay, thank you very much. There's a couple of questions now on reimbursement to employees and another question on salary decreases. So first I'll go to the question, is there a legal framework that exists, either it was pre-existing or else it came in during COVID-19, that helps to guide employers about how to pay back or refund gasoline or parking fees or highway fees to employees?
In Japanese labor law, there is not a regulation on expense on commuting. And so basically, companies don't have to pay it. But if there is a provision that says they provide the expenses, it becomes mandatory. There is no particular regulation related to COVID-19. But of course, as I mentioned, from the viewpoint of equal pay for equal work, you shouldn't set irrational gaps between full-time and part-time, and between temporary and permanent workers. And just for reference, to pay the actual amount as expense on commuting, actual amount, it means that the company allows the workers to commute by their own car officially. If the company is regarded to be positive in introducing commuting by car with it, the possibility that the company has to pay damages for traffic accidents caused by the workers will become higher.
Okay, thank you very much. And this one is to do with salary decreases. So is it possible for an employer to unilaterally decide on a salary decrease? Say if, for example, the sales this year less than last year by a certain percentage?
Basically, lowering working condition in a unilateral way is, of course, very difficult. Under Labor Contract Act, changing working conditions in a manner disadvantageous to the worker should be done generally by agreement with the worker. And if there is a labor union in the company, changing labor agreement with the union is another way. But anyway, either way needs to get the consent. If the company wants to change the conditions without getting consent of the other party, they can change the rules of employment. But of course, there is a limit. In this case, rationality is required, considering factors like necessity on the side of the company, the degree that it affects workers disadvantageously, and so on. In detail, it is stipulated in Article 10 of Labor Contract Act.
Okay. Okay, good. And a couple more questions to go through. I think we should have enough time for those, and one more has come in on the chat. So I'll ask the question that's come through, Chiba-san, and then go back to the other questions. This question, thank you, Jennifer. Should companies attempt to reimburse employees for additional costs that came about by teleworking, such as air conditioning or electricity kind of costs from working at home? That's the first question. Good question.
Yes. It is a very current problem nowadays. And generally, the company should reimburse some fee about it. Because it is inevitable to use some cost in business. It is important. It is necessary for us, for the companies, to pay something for it. But it goes without saying that to decide the amount of fee is very difficult. So we have to deem it to some extent. Some companies are paying a kind of allowance for the purpose of compensating the cost. So we have to do something like that.
So instead of everyone's power and electricity being very different each time, so some companies are paying an amount as a subsidy for the employee.
Yeah, that's right.
Yeah, that sounds like a good workaround. And one other question about calculating work hours when people are working at home. So it seems to be very difficult to do that objectively. And so the question is, you know, some companies are deeming that employees work regular working hours, such as 9 to 5. They deem that. So in this particular case, we asked employees to let us know if they worked overtime outside of the 9 to 5. Is that a good way to approach trying to keep track of overtime hours for those working, doing teleworking?
Okay. We asked the employees to let us know if they need to work overtime.
Yeah, so as a default, they said that this company said 9 to 5 are your working hours. If you work before 9 or after 5, please let us know so that we can record the overtime. Is that a good way to approach this?
I think it's a good way, of course, because it is beneficial for the workers generally. Basically, the companies can deem the amount of the working hours because of the system in Japanese law. But there are some cases that the workers have to work overtime in a particular situation. So perhaps this question means that in such cases, the companies are trying to know the situation properly, and if there's some overtime hours, they are asking the workers to report it. So in the end, it is beneficial for them, for the workers. So I think it's a good way, and if the company can do it, it is very good in the end.
Yeah, I think you're right. That it's beneficial because they have their certain hours they know is regular time, 9 to 5. And then it's also beneficial because they can easily report outside of that time if they had to do urgent request for a customer or deliver a report to someone. They can at least let the employer know those outside of those hours. Yeah, great question. Thank you so much. One further question. I think we're probably going to have enough time for both of these. We've heard a lot about the furlough schemes, right, that are in the UK, the US, Australia, New Zealand has also implemented these kind of furlough schemes. Are they also in Japan, or is Japan a little different?
There are some schemes in Japan, such as in Japanese, they are called Ichiji Kikyu or Ichiji Kaiko, and so on. The first one, Ichiji Kikyu, who means that the company orders its workers to stay at home for a certain period. It was reported that some airline companies have done that. And the second one, Ichiji Kaiko, or Kaiko means layoff. So Ichiji Kaiko means that a company dismisses its workers, promising that if the situation becomes better, they will re-employ the workers in the future again. Regarding the first one, Ichiji Kikyu, when a company uses Ichiji Kikyu, the company have to pay at least 60% of the employer's salary in general. And if the reason for the layoff is attributed to the company, and if the reason is attributable to the company, the employer has to pay 100%. And regarding the second one, Ichiji Kaiko is a dismissal, but substantially it is a termination agreement. which means getting the consent of workers is necessary. Under Japanese law, I can't recommend this ichiji kaiko. Depending on the case of the company, the worker's consent may become invalid. And if the company intends to use this system to have the workers get employment insurance benefits, it may be regarded as a fraud in that they are only taking the form of dismissal. So I'm strongly against with this method, ichiji kaiko.
So you don't recommend that, and it sounds like that's the reason why we probably have not heard about furloughs happening in Japan, and that makes great sense. Okay, we've got time for one more. Emily, give me a thumbs up if we're ready for one. Great. Final question then, Chiba-san, is about an employee who's in the middle of renegotiating an annual contract, and the company is delaying the renewal because of this pandemic. Assuming that that contract does get renewed, will the employee be able to receive compensation from the time between when that contract had ended and when the renewal starts?
If the worker has been working after the first contract ended, there must be a reason why the employer was able to have the worker work. In other words, usually in such a case, there is an implicit contract. So wages, not compensations, wages during the period should be paid.
Right, that makes complete sense. All right, I think that brings us to the close of the Q&A, and I really thank Tim, Jennifer, and others who have posted questions live, and also to the people who posted beforehand. It's been really great for that, and I really appreciate everyone's active participation today, and I hope it was very informative for you all to touch upon labour law issues. We did show Mr. Chiba's details there before, and again they'll be posted on the site for us later on the events repository, for the want of a better word, or there they are again popping up. So you've got Mr. Chiba's details. Do reach out to him for your specific labour law questions. So that does bring us to a close. I would like to head back to Emily now, just to close up, Emily, and let us know what's happening in the ANZCCJ coming up. Thank you very much, Chiba-san.
Thank you, Catherine, and thank you very much, Chiba-san. It's been an excellent session with you this afternoon, a very relevant topic for all of us here in Japan. So again, Chiba-san has covered a lot of information for us, but if any of our guests do have any further questions, please feel free to reach out to him directly, or alternatively, you can contact us here at ANZCCJ, and we are always happy to connect you. Before we go, I will remind our guests that a recording of this session will be available on our ANZCCJ event gallery, which is available on our website, alongside a copy of the slides from Chiba-san. Our next webinar will be the first in a series of online Japanese tutorials, which we are joint hosting with ANZCCJ members JSL Nippon Academy. So this will be featuring their head teacher, Ms. Ikue Miyazoto. And this first webinar will cover a range of useful greetings in Japanese that can be used in multiple contexts, as well as some hints for business etiquette, including business card exchange. This will be held next Wednesday on July 29, and details and registration are available on our website. So that's all we have time for today, but thank you once again to Chiba-san and Catherine, and to everyone who has joined us online. And I wish you all an enjoyable weekend ahead. Okay. Thank you.
Thank you very much. Bye-bye.